second instance of contempt is on 3rd of September. And my lord, you issued orders at 10 a.m. There was no appearance. You issued further orders at 3 p.m. There was no appearance. My lord, those are 3 instances. My lord, on 5th of September equally, you issued orders that he appears on 5th of September at 10 a.m. He did not appear. A 5th instance of contempt in court. You directed, you were gracious enough to direct that he appears at 3 p.m. My lord, he did not appear. Cumulatively, these are 6. Today morning, it's the 6th instance that the Inspector General of Police, the first respondent, has refused to comply with this court orders. My lord, that is the context within which we find ourselves as petitioners in this matter. Will this court give another chance for the Inspector General to appear before it? My lord, if that is given, then it will be a further violation of the Constitution, particularly Article 10 of the Constitution. The Inspector General has a duty, which duty is appropriated. Your directions were that he himself, not his deputy, appear before you. Having given that context, my lord, I want to invite President Nelson Harvey to make his submission.
My lord, it was not my expectation that I will stand here today, having stood in this very court about 5 years ago before your brother Justice Luka Kimaro on a matter similar to this. Having appeared before this court again 7 years before your very same brother Justice Luka Kimaro on a similar matter. I'm talking about the matter of Miguna and the matter of Wayne Kimani. My lord, the conduct of the first respondent must be deprecated by the court. And in the strongest terms possible. My lord, the very criminal justice system that the first respondent stands for is incapable of performance but for reliance upon court orders. It will therefore be turning logic over its head to allow the National Police Service, which comes to this court day after day for summons, to compel attendance, for warrants to enable search, to fail and attend court, to give an explanation as to the whereabouts of 3 Kenyans. Lord, it is for that reason that at the tail end of this discourse, we will ask the court to do 2 fundamental things. 1, to convict the holder of the office of Inspector General of National Police for contempt of court. And 2, sentence the holder of that office to the highest permissible penal consequence. And if 6 months is the highest permissible penal consequence, it must be cumulative for the 5 orders hitherto disobeyed. And fundamentally, my lord, this is not a personal office. It is a public office. So that as you convict and sentence, my lord ought to make a declaration of violation of the Constitution. My lord, allow me just to refer to 3 authorities and in very brief. My lord, the first case is the case of Dr. Fred Matiang'i, Dr. Fred Matiang'i versus Miguna. Sorry, it's Miguna versus Dr. Fred Matiang'i. Petition number 51 of 2018. It's reported as 2018 UK law. Lord, your brother, Justice Odunga, as he then was a judge of the High Court, was met with a case where the then Cabinet Secretary for Interior had refused, one, to appear in court and explain the whereabouts of Dr. Miguna. And secondly, it failed to produce Miguna in court. Lord, at paragraph 11 of the decision made by the judge, your brother judge, he underscored a fundamental concept. He said, in this case, it is clear that the respondents are the ones in charge of security in this country. They are in effect in charge of execution of warrants of arrest. They have clearly shown that they have no respect for the rule of law and will not comply with the orders of this court. Lord, in reliance upon that limitation, Justice Odunga proceeded to declare the contempt there as having violated Article 10 of the Constitution. Rightfully so, because we asked for that declaration in order that Fred Matiang'i, the then Director of Criminal Investigation, George Kinoti, and all the respondents should not hold public office. We want Gilbert Masengeli not to hold public office, because this is not his personal property. Lord, the second authority I want to refer your lordship to is miscellaneous criminal application number 57 of 2018. It's reported as 2018 UK law. But this is a serious enterprise. My classmate Charles is a studious practitioner. He has this. And we argued this case with him. They have discovered.
Let me finish, because now we cannot stop the video. And then if you need time to look at the authorities that will
That's okay. Thank you so much. Well, the second decision that I'm referring to, that is the case miscellaneous criminal application number 57 of 2018, reported as 2018 BKLR. The responsibility, similar to the one bestowed upon you, fell on the shoulder of your brother, Justice Luka Kimaru, a judge of the High Court as he then was. And my lord, significant to this enterprise is what the judge said about the right to be heard. And this is what he said. If the second and third respondents chose not to appear before court and give their extenuating circumstances, the court will have fulfilled its legal obligation of giving the second and third respondents a chance and a hearing before the final verdict. And not simply put, for the ease